Good evening. Welcome to our event tonight. My name is Lewis Cooper. I'm the president of Gay Grassroots in Northwest Florida. Thank you all for coming out. The first order of business for the evening is, as some of you know, our guest speakers did not make it today. And I'm sorry about that. Ms. Schwartz and Ms. Martin were flying in from Miami, and they had plans to go on to New Orleans after they left here. And the weather was just too uncertain for them. And I'm very sorry for that, and they are too. We'll continue without them anyway. But I am happy to say that we have a speaker tonight who I think will be every bit as interesting. You know, they say a prophet is without regard in his own hometown, so don't feel insulted we didn't ask you first, Joshua. Our speaker tonight is going to be Joshua Jones. He is an attorney here in Pensacola. I think it would be fair to say you specialize in family law as one of your areas, and in particular LGBT family issues, along with some other stuff. It's very interesting. But I do want to just let you all know before Josh comes up that this is an event that's part of Pensacola Pride 2017. Many of you were at the park on Saturday when we had the festival in the park. That was a really wonderful event. I was so glad with the turnout we had and the enthusiasm of the people we saw out there. Then on Monday night we had an LGBT advocacy workshop that we had a really nice turnout, and it was at the downtown library. That was led by Doug Landreth, who is a past president and one of the founders of Gay Grassroots. And then on Saturday, this 2 days from now, we have the finale of Pride 2017, and that is the celebration ball. That is a catered banquet with live entertainment, and that is the only event for Pensacola Pride 2017 that requires a ticket. The tickets are $45 if you buy them ahead of time, and $50 at the door. And the door, by the way, is at the Pensacola Opera Center downtown, kind of in front of the new YMCA to a degree. But that's the only thing we've charged for this year during Pride, and mostly that money goes back into supporting our efforts and will be used to get next year started and other events. But it's a 4-course meal. There are cocktails and wine included, and we're going to have a live cabaret, a presentation from the Coastal Cabaret Ensemble, I believe is their name. And I can't wait to hear them. I think it's going to be a lot of fun. But welcome tonight. Before I hand it over, if you would like a ticket to the ball, we have those for sale in the back of the room. Asher Balfour, say hello, Asher. Hello. He's our treasurer. He's selling tickets. Like I said, they're $45. We also have Pride T-shirts for sale back there. They're $20 each. Has a really nice design on it. Those T-shirts have been very popular this year. And you can pay You can pay membership dues if you would like to support Gay Grassroots with your membership. It's only $10. We're really, this year has been the first year that we've taken memberships. We want to build a base of people who are interested and willing to help the group and help the community and be social with each other and organize a little bit. So any of those things you would like to accomplish, you can do those at the back of the room. I also say, you want me to talk about the books? Sure. One of our speakers, Elizabeth Schwartz, was going to be reading from her most recent book, which is called Before I Do, and A Guide to Marriage, Gay and Otherwise, I think is the title. And she was going to be selling and signing those books, but the books she had sent ahead, and so the books are here. And she's actually offering them tonight at a discount. Normally they're $15, and she's going to offer them. Joshua's firm is selling them for her in the back of the room as well. So if you'd like to pick up a book, it looks like a really interesting read. But I've mumbled and stumbled enough. I'm going to turn it over now to Pensacola Attorney Joshua Jones. Thank you, John.
Good evening.
Good evening.
Thanks so much, Louis, for the warm introduction. I am surprised to be here. I've never given this particular presentation before. I created it about 3 hours ago. I didn't know about tonight. I didn't know I would be presenting tonight until late last night. And I was looking forward to seeing Elizabeth as well. She is someone that for years I've communicated with via email and telephone. She works in Miami, and so given that her focus is largely representing gay and lesbian clients, and my focus is largely representing gay and lesbian clients, we often consult with each other via email. So I am going to do my best to plug her book because I really think it's a good book. It's written in a way that is plain English. It's not a bunch of legalese, so it's accessible to a very broad reading comprehension ability. And it poses a lot of very important issues that you should consider before you get married. So bear with me as I realize that this is the computer, not that. Let's see. Why are we not? I'm not sure why we're not moving forward. Unresponsive. Do we have an IT person? Oh, here we go. So this is Elizabeth. Elizabeth Schwartz. She works in Miami, as I said. And the name of her firm is Elizabeth F. Schwartz Attorneys and Mediators. She led the Pareto case, which was the Florida marriage equality case. And obviously, she won that case. It was in collaboration with the National Center for Lesbian Rights. And it came out before the Supreme Court case that created marriage equality across the country. The book that Louis just mentioned and I mentioned is Before I Do, A Legal Guide to Marriage, Gay and Otherwise. So though she markets to the gay community, I share her philosophy that we are now pretty much facing the same issues as a heterosexual couple when we're considering what to do pre-marriage. I would list her awards and honors, but if you ever go to her website, it is the most astounding list of accomplishments that it makes me feel like I'm not working hard enough. So I do encourage you to see. She actually is very involved in the Jewish community in the Miami Beach area and does a lot of work with gay and lesbian Jewish organizations. And she, of course, she's very well respected for her work on behalf of gay and lesbian clients. She is board certified in adoption, and she's pretty much the go-to person in the state if you have any questions about adoption or also reproductive technology such as surrogacy and sperm donation. I've often consulted with her about adoption. And she's super smart, right? And the great thing about her too is that if you call her or email her directly, you don't get a response from her paralegal, you get a response from her. And that's not just true because I'm another attorney. She really is great about returning personal phone calls and emails. So while I hope you'll come see me in Pensacola, if you called Elizabeth, she totally will call you back. So I am not Elizabeth Schwartz, obviously. I am local. I did not grow up here, but I've lived here for, I got 14 years now. With a small break to California. And my practice is pretty broad. I do a lot of estate planning for gay and lesbian couples. I found that my clients tell me they've waited for years to get this kind of work done because they felt intimidated by the legal profession as being some sort of conservative and unwelcoming profession. But that really is not the case. I've never been in the closet in my profession. And I've never encountered any sort of discrimination among my colleagues. Maybe they say stuff behind my back, but I never heard anything. So, but I know that people find it intimidating, and I would encourage you to stop thinking about it and at least schedule a consult, if not with me, with any of the other family or estate planning attorneys in town. It's very important basic adult life documentation that you need to have. And I'm also super smart. So Elizabeth's not with us, but here am I. And we did not say, but if you have any questions while we're going through this, I really don't mind interruptions to answer questions. I will also say that I see a couple of my clients in the room, and as a reminder, I do not approach clients in public unless I am approached first, as a matter of confidentiality, which I think a lot of lawyers don't take that seriously, but for example, my husband is here with me filming, and he knows that if I know someone he doesn't know, that that's probably a client. So it implies a breach of confidentiality. So don't be offended if I don't talk to you and you're my client. You have to talk to me first. My practice too is, I think of it as preventative lawyering or proactive lawyering. I want to help you plan ahead with the proper documents and contracts so that you personally or your business don't later encounter a legal problem that you're going to have to clean up. I also like to be, like if you think of a general practice physician, and you usually go to them first before you see a specialist, I also want my clients to think of me in that way. I am not a specialist in some particular areas of law, right? I don't practice medical malpractice. I used to. And so if a client came back to me and said, I have this medical malpractice problem, what do? I will still talk you through it and help you figure out the right law firm to go to. Because even within that practice, there are medical malpractice people who are very specialized within that. And so the other thing is that I don't want you to feel like you have to go to a brand new attorney with every new legal issue, because every time you go, you're going to be spilling all your confidential information all over again. And if I have an ongoing relationship with the family, then we don't have to expose your personal information all over town. So that's sort of my practice philosophy. And we'll get to it a little bit later, but I also work with a legal method called collaborative law. And it's fairly new in this area, very common in South Florida. In fact, Elizabeth is the co-chair, I believe, of her local collaborative practice group. And she and another lady have sort of led the charge towards applying this in the gay and lesbian community even before marriage equality. It's a much healthier way to solve problems, much less expensive as well. So we'll talk about that in a bit. But before we do, this book that she keeps talking about, I did offer to sell it for her since she's not here, because I know she would do me the favor if I had to abandon a trip to Miami. And I have read parts of it, but not all of it. And so this is directly from her. She wrote this in like page 2. So before I do, is for couples who have been coloring outside the lines and now are considering making the relationship legal. It explains what marriage means and does not mean. It spells out all the implications of marriage in a straightforward, easy to follow style. And that is Elizabeth Schwartz. And it has been incredibly well received and very informative. You can buy it on Amazon, or you can get it directly from her law office. So if you don't have an Amazon account, just give her a call and she'll send it to you. For tonight, we're only doing cash because I don't have a portable credit card reader. And then we'll just Venmo her the money or something. So within the book, it's presented in a series of hypotheticals. So it's sort of learned by example, or if you've been to business school, it's sort of a case study method, but very brief examples. And it really helps drive home the legal policy that she's trying to get across. And she also included several articles from guest writers who are noted professionals on particular subtopics. So it's not just her writing, it's her inviting others to write as well. And to me, that makes it a little bit stronger book, because you're not just getting this one perspective, you're hearing it from a number of attorneys. And the reviews have been really great. As this has highlighted, this book is essential for LGBT couples, and I agree. In fact, I'm a little bitter that she scooped me on it because I thought of writing this book myself. I'm going to have to figure out the new twist. So for tonight, because I did not write that book, and I have not read all of it, we're just going to talk generally about the current state of gay and lesbian rights and transgender rights in the United States. And to get us there, we will start with some sort of history, like how did we get here? So we'll talk about the Obergefell case. I always mispronounce that. That's the Supreme Court case that gave us marriage equality across the country. We will talk about U.S. v. Windsor. And we will talk about the Pareto case. And then we'll get into, so that's sort of the past, right? So then we'll talk about current issues. And believe it or not, there's still a lot of litigation that needs to occur before it's a flawless, seamless system as heterosexual couples have with marriage and divorce. Discrimination, still an issue that we need to deal with. Many couples do not wish to marry, and so we can talk about how to address those concerns. And reproductive rights and parenting responsibilities are a huge problem. It's really astounding how many recent cases there are in Florida on this very topic. It is a constantly evolving area of law. And it's very well covered in your book. And then we'll also talk about future issues. For example, we still don't have an equal rights amendment in the United States that would protect women and all other minorities. We do have, the Civil Rights Act of 1964, which the EEOC has been great about expanding as we go, but officially, it's not including any of the LGBT community. We will also talk about what we can do to help transgender persons, because now, I don't want to say that the gay and lesbian fight is over, but for sure, I think that the transgender visibility is creating a bit of a backlash, and we all need to be cognizant of that and respect them and help them through as they ramp up their efforts for equality. And then, obviously, I'm going to talk about collaborative law because I'm so excited about it. And then, just as a reminder, we have to encourage voter registration among the LGBT community. And I'm glad to be here at a college tonight and see young people here. I don't know if you're here because you have to be for a credit. I applaud you for making it on a random night where it's so hot outside. But if you are not registered to vote, it makes me very sad. Let's talk about how to get you registered. It is so simple. And you need to actually go and vote, not just when we have presidential elections, but especially for the midterm elections in 2018, you must vote. So, case law that settled the issue of marriage equality. And you see that I include a question mark because I don't think it's totally settled. As I said, we still have a lot of issues that need to be cleaned up. So, I'm going to catch ahead here. And also, if I forget to move the slides forward, somebody please just tell me, because I will start talking and forget about it. Any questions yet? No? All right. So, the Windsor case, this is the one that involved Edie Windsor. She's actually been in the news quite a bit the last few weeks because she was the Grand Marshal at Capitol Pride a couple weeks ago in Washington, D.C. It was really, really spectacular to be there and to see her in the car. And she's also been in the news because she just got remarried, which is kind of a surprise because her case was, even compared to the Obergefell case, which was much more important in terms of universal marriage equality, she really was sort of the darling of the movement and very visible and highly publicized because she was a sweet little old woman. And it was kind of surprising that at her age and after all that publicity about her marriage that she would remarry. I don't know her personally. I'm happy for her. But that's the person you've been hearing about, Edie Windsor. And so she was in a relationship in New York. She got married in Canada. And then when her spouse died, the estate was so large, the spouse's estate, that the IRS would not allow her to inherit that huge estate and apply the spousal exemption for the estate tax. So, backing that up a little bit, if you are married and you leave a huge fortune to your spouse, you can do that without tax consequences. If you leave all that money to someone who is not your spouse, there's an estate tax, and it is very, very expensive. The amount, the threshold amount that will trigger the estate tax, right now it's $5.25 million for an individual, and then when that spouse dies, it would be $10.4 million. And that threshold level changes from year to year depending on what Congress does with it. And so her tax bill was going to be about $600,000. And so the U.S. Supreme Court said a very small portion of the Federal Defense of Marriage Act was unconstitutional, and the U.S. government must recognize any valid marriage from any state. So basically, the federal government's not doing this anymore. Edie Windsor's not going to have to pay these taxes. Her attorneys got lots of money from the government because they had to pay her attorney's fees. It was really, and this is one of my biggest pet peeves, is municipalities and government entities that continue litigating issues that are no longer issues, that have long been settled. And I don't really have an opinion one way or the other about the Cross and Bayview Park, but it is a great example of wasted tax revenue on litigation that has long since been settled. And until we start telling our representatives that we are sick of wasting much needed tax dollars on legal issues that were settled 2 decades ago, this is going to keep happening, because these representatives are not necessarily legal scholars that understand legal precedent and how that still carries forward and is still enforceable. So particularly the Bayview Park Cross issue, it really gets my goat. That was a lot of wasted money by the city. Any questions about the Windsor case?
I have a question.
Sure.
Looking at the piece that says the United States must recognize valid state marriages, this marriage occurred in Canada, so that's not a state of the United States. Can you speak to that just a little bit?
It's probably in eloquent writing. I shouldn't have included state.
Okay.
Just simply put valid marriages.
Okay.
Because all of the states and the United States, if the marriage was valid in the foreign country where it was performed, it is valid in the United States.
Thank you.
So, I mean, was that an issue that the marriage was valid in the state of New York, but not at the federal level? Was that part of the case?
I mean, that was part of the confusion, right? Because New York didn't have a problem recognizing the marriage, but the federal government would not because of the Defense of Marriage Act. I saw a hand over here. No? All right. So that case was in 2013, I believe. Might have been 14. And then the Pareto case is the one from Florida, which it was so frustrating, right? Because I think they had already argued Obergefell in the Supreme Court, but we were still waiting for a ruling. And then the ruling for Pareto came out, I think it was January 2015. And then Obergefell ruling came out in June of 2015. So it's kind of frustrating that these plaintiffs in Florida had to keep pushing this forward when all the time, those months of arguing before the Supreme Court in Florida, all that time, the Supreme Court justices were working on the opinion for Obergefell. And so this case, it actually involved 6 different couples, and they all had a slightly different reason for challenging the marriage ban in Florida. One of them was a probate issue, one of them was a parenting issue, one of them was about probate maybe, but they all had just a slight little unique tweak in why they were bringing their case. And obviously they were challenging both the constitutional amendment that had been enacted, I think it was 2004, and they were also challenging the various statutes that speak to marriage in the state of Florida, because they're all very specific about man, woman, and so forth. And I really encourage you to seek out this opinion. If you want to email me, I will email it to you. It is very beautifully written, as are the Windsor opinions and the Obergefell opinions. It's some of the most, I don't know, touching you get a sense of humanity and concern from the justices in all of these cases. So in this one in particular, they really went into some deep history about marriage rights going all the way back to the beginning of history, specifically the Loving case. And the justices in the Pareto opinion, you could read clearly that they were mad that the state of Florida did not even bother to mention the Supreme Court case of Loving versus Virginia. You may have seen the movie recently. Loving versus Virginia is about interracial marriage. And the couple lived in Virginia and they were arrested for living in interracial marriage. And how the attorneys for the state thought that they were going to make an argument without mentioning that Supreme Court case, especially when the plaintiffs had made a big deal of it, and they completely ignored it in all of their filings. And the judges called them out for that. And I don't remember the exact quote, but it was pretty much saying, well, how can you not even mention Loving, much less fully address it? Because Loving was the precedent that ruled the day. And so the Florida Supreme Court said marriage is a fundamental right, including for gay and lesbian couples, and they voided the constitutional amendment and the various statutes about marriage. Any questions about Pareto?
Well, I have a question in specific about, I would have also, I remember I met one of the 6 couples, and I remember thinking it was not going to be a possibility because I didn't think that we could override what the constitutional amendment said. And that would be my ignorance on how law works, but I would assume that possibly I'm not the only one that would question that. So how did that relate? How could Florida go above the constitutional amendment?
So this was addressing both the U.S. Constitution and the state of Florida Constitution. And so both the U.S. Constitution and the state of Florida, they give us fundamental rights. And so as a matter of privacy in Florida, marriage is a fundamental right. Under the U.S. Constitution, it had already been declared a fundamental right by Loving versus Virginia, though for some reason they would never apply it to gay and lesbian couples. So sort of your original question is how could the court override the constitutional amendment, which obviously we as voters adopt these constitutional amendments, and that's a huge piece of current politics is the will of the voter. Yet if we go back to the early 2000s when those conservative voters were gladly, subjecting their will on the people with all these marriage amendments, you weren't really hearing any complaints then. So when we think about the separation of powers among government, the checks and balances, the judiciary has the authority to interpret these constitutional amendments. And so the Florida constitutional amendment, Florida Constitution can never override the U.S. Constitution. The U.S. Constitution, whatever applies to that applies all over. And so the Florida amendment violated the U.S. Constitution. So the justices, they were allowed to say that. And logically, anything in the statutes that relates to enforcing that now unconstitutional Constitution amendment would have to be voided and taken out. And we'll talk about it in a minute, but there's still a lot of statutory cleanup that needs to happen. Did I say another hand?
Yeah, to that point, and without asking you to comment on any specific case, of course, I'm just wondering if I'm the only person. My wife and I got married in Connecticut in 2014, in March of 2014, because we didn't see all this on the horizon. We didn't think it would be legal in Florida. And then, of course, it became legal in Florida in January of 2015. But instead of, when normal people get married, you're able to enroll on their insurance right away, spousal benefits. It's considered a change of life event. But without going into employers, I was denied that. They told me that I would have to wait until open enrollment. So I had to wait from January to October, even though I had already been married more than a year at that point. And so that is coming to mind when you're saying there's still some cleanup to be done, and I'm wondering.
Very legitimately could have been applied in your situation, because they have a period of time where nobody's going to be joining the policy. And whether they will let a new spouse join before the open enrollment period, it really depends on the particular company and the particular insurance company.
What if it's a government agency?
I don't know. Again, if the government agency is using a private insurance company, it would really depend on how the policy reads, I think. And you know, whether you could go back in time to sue the government, for example, for out-of-pocket medical expenses, I don't know. Maybe. I've not heard of a case like that, but anything's possible, right? Everybody gets their day in court, even if they are not going to win. So, I don't know. That's a good question. Now, there was that period of time, though, right, where everything was sort of like, oh, well, we don't really know how this is going to work. So there was a period of time where Social Security, they didn't know how to apply all of this. Like, if you got married in a state but lived in a state that didn't recognize marriage equality, should the Social Security system recognize that marriage or no? So there was a good 12 to 14 months where there was uncertainty among the government agencies. And now, after Obergefell, that's all sort of gone away. But there's still very specific issues that need to be litigated for cleanup. So that I think we have another 10 or 15 years of litigation to be full marriage equality and everything working the exact same way as heterosexual marriage. So the Obergefell case, and if you're from Ohio or French and know that I'm butchering that name, please speak up. The primary case was out of Ohio. This was actually 6 different cases from that Federal Circuit Court of Appeals, but the primary one was the one out of the state of Ohio. You might see pictures online of the couple as they were flying to get married. He had, I believe it was ALS, the partner that was dying, which is terrible, terrible affliction. So they wanted to travel and get married before he was too bad off to travel. And when they got back, they wanted to ensure that the other spouse would be recognized on the death certificate. And after inquiring with the state, they said, no, we're not going to recognize that marriage from the other state. You won't be on the death certificate. And obviously, not being the spouse on the death certificate leads to a whole avalanche of other problems. You need that official recognition as the spouse, for example, to get Social Security benefits. And so they actually sought a declaratory judgment before he died to decide what would happen. And the U.S. Supreme Court took a while to get there, right? Said that marriage is a fundamental right, and they overturned the case of Baker v. Nelson. Baker v. Nelson takes us way back to like 1973, and that couple, I believe it was Mr. Baker, who was a law student at the time, and so he had the great idea of, well, let's try to get married, and we'll see what happens. So he really is the pioneer within the marriage equality movement. And of course, I believe it was Minnesota, they said, no, we're not going to do that. So then they filed the federal case as, due process violation. And when it got to the Supreme Court said, no, we're not going to grant review because this is not a federal issue. States have the power to regulate marriage. But keeping in mind that not even a decade earlier, in Loving versus Virginia, they were glad to consider marriage as a fundamental right. So clearly, that was about, we're not even going to touch this because we don't think the country's ready to hear this case. And that is often what happens at the Supreme Court. Jeffrey Toobin, who you will see a lot on CNN and on NPR, he's a writer, he writes about the Supreme Court. It's a really great book about the history of all the justices and their sort of thought process of how to take a case and how to reject a case. And it is very often that they reject a case because they don't think that our society is ready to consider that issue on a broad scale. They really are looking for cases that have a huge, wide sweeping impact, or cases that have a very important sort of technical procedural question behind them. And speaking of procedural questions, if you research the history of any of these cases and the technical process that they went through to get all the way up to the Supreme Court, it is like traveling a maze. I'm so glad that this happened before I graduated law school. I mean, after I graduated law school, because it would have been an incredibly intense exam question to work through the civil procedure on these cases. It was a lot of back and forth and requests for rehearing. It was really amazing. So, as I've hinted to, with the current issues, yes, there's going to be a lot more litigation. It's not going to be litigating, I know, but Elizabeth and I are so smart, how can there be more litigation? But like I said, there's still a lot to clean up. And it's not as simple as just saying, oh, well, we'll just apply the law that we already have, and when I say the law, I mean statutes and case law, to the gay couples, just as we've applied it to the married couples. But that's not really fair, because heterosexual life doesn't really translate perfectly to gay and lesbian life. And as we talk about some examples, that will become more clear to you. But you simply can't just say, oh, one size fits all with all this precedent and case law. So an example of that is, let's say, I'll use my own relationship as an example. So Wesley and I met in 1996, and we took the lesbian route and moved in real quick. No offense, lesbians. So we were living together pretty quickly, and really, it was love at first sight. It really was. I'm not being cheesy. It was soulmates from the minute we laid eyes on each other. And from that minute, we really were sharing money and furniture and everything. And in 2001, we got a civil union in Vermont, right? So that sort of said officially, okay, it's basically marriage. And then later, like 2014, we were able to convert the civil union to a marriage. We had to go back to Vermont to do that, because the only way to get married if you have an existing civil union is to dissolve that civil union first. And by going to Vermont, we were just able to convert it. We didn't have to actually go through a quasi-divorce process through their courts. So obviously there was this gap of time where we were totally together like a married couple, but in Florida, when you get divorced, the court looks at the date of marriage as the date that you start acquiring marital property. And it's that marital property that's going to be distributed in the divorce process, and we call it equitable distribution. So, if my date of marriage is 2014, but I've just had almost 20 years of life with this person, is that fair to the gay couple to say, oh no, your assets weren't even marital until 2014? There's a gap of logic there. And so among other family law attorneys, when I have this conversation, some of them are very stringent about the idea that, well, why on earth we wouldn't apply it the exact same way as we would to a heterosexual couple? And the obvious argument is because we didn't have the opportunity to get married. We would have if we could have, but we couldn't. But as a matter of equity and justice, why would we ignore that huge period of time where we were cohabitating and sharing money? So we don't know what the courts are going to do with that yet. I mean, there are some other avenues for addressing that premarital property, but it's no different from what we already had to do when gay couples broke up. So for example, a cohabitating gay couple that wasn't married, that owns property together, figuring out how to divide that was just a matter of contracts and negotiating and coming to a settlement agreement. And you did not get the benefit of court supervision. So you could file a related real estate case that would be separate and included in the current divorce, but that's ridiculous, right? So we need some Supreme Court case law in Florida to clean up that gap of what do we do when somebody was cohabitating and couldn't get married. Does that make sense?
I have a question on that. Will your view of that change from 2015 going forward? Because from 2015 going forward, you have the right to get married.
Yes, it does change for me.
So it's just before, all of us who were together before that.
Right.
Gotcha.
And I would also say that once civil unions became readily available and domestic partnerships, if that couple did not avail themselves of that first step to solidifying their relationship before the government, then I would agree. Maybe they didn't intend to get married. Just like a straight couple cohabitating for 20 years, they had 20 years that they could have gotten married, and they chose not to. So in that instance, I don't feel bad for that 20-year gap of non-marital property. For my own relationship, I would hope that the court would look to the date of the civil union. In my estate planning and postmarital agreement, we go all the way back. Speaking of postmarital agreements and prenuptial agreements, please, please, please get one. If you're considering marriage, it is not expensive. It will save you tons and tons of money if your relationship dissolves later, because you will have already explained exactly what's going to happen with everything. And of course, nobody is getting divorced, right? Everybody says, oh, we're so in love, we're never getting divorced, ever. Why would you say that? Well, there's still a thriving divorce practice in Pensacola. So no matter what you think today, there is a real possibility that you might end up divorced 10 years from now. So now, while you're getting along and can make these decisions together, go ahead and create a prenuptial agreement before you get married. And you will thank me when you get divorced. Parental rights and responsibilities is the huge issue right now. Like I said earlier, this keeps coming up and keeps coming up in the courts, because now, you know, it used to be that, like in the 80s and 90s, if someone was going to use artificial insemination, they would most definitely go through a doctor, right? Because we didn't have ready access to information like we do now on the internet. Now, everybody's a doctor and a lawyer, and they're going to do their own insemination at home with a turkey baster, and they're not going to document any of it with a contract. And so then, is that really a sperm donor when you didn't bother to document it with a reproductive technology contract? And then, you know, we have this gap between how lesbians are treated in this situation and how gay men are treated in this situation. So the case DMT, I forget the other lady's initials, they were a lesbian couple, they had their gay friend donate sperm, he gladly signed off on everything and gave up his parental rights. One woman gave the egg, the other woman carried the baby. So now they both had a biological connection to the baby. And the court believed in that, and they had equal parental rights out of that case. The woman who gave the egg was challenging the other woman as if she was not the parent. And obviously the court said, you both have a biological connection. This was clearly your intention for this child, so it's both your kids. On the flip side, there was a case about the same time, maybe a little later, and the gay man who had donated sperm to the lesbian couple broke up, and one of them didn't want anything to do with the kid. And so he wanted to step in as the father. None of it had been documented by contract. And because it hadn't been documented by contract, the court considered him a sperm donor, and he had zero rights to the child. So it's almost sex discrimination, right? To treat that scenario very different. It was a nearly identical scenario with the exception, and you know, he had a biological connection to the kid, right? But it reiterates that don't go doing these things without consulting an attorney first. Surrogacy contract work is incredibly complicated, and I would not recommend you hire many people to do it, because one little thing and the child's life and your life is potentially ruined later down the road. Polyamorous relationships. The room gets really still, right? Should polyamorous, I'll say thruples or quadruples, should they also have the right to marriage? And if not, why wouldn't they have the same right to marriage? If they're all consenting adults and that's the relationship that works for them. I'm not afraid to say that I would totally support a law that allowed polyamorous relationships. I've documented a few through estate planning, and it really, they're very normal. It's not like they're, horny sex hounds that are, just in it for the body. They really are a relationship and very equal among them. So this idea that we should shame them for being less than a two-person couple, I just don't get that. And I do think that this is developing case law that's going to be going to the Supreme Court eventually.
Would that be something that correlates also, that was well documented on some of my reality TV on the Mormon Relationship? I don't remember the name, but it was a family and they had to move from Vegas to, or one or the other, from
Yes.
Utah to Vegas. And that would, for all practical purposes, would be a polyamorous couple because it was one man with many
Yes.
wives. God love them. But
So there are a couple of laws that are already on the books that impact polyamorous relationships. One is the prohibition against bigamy, right? You can't be married to multiple people. Also polygamy, right? But polyamorous relationships at the moment, usually only 2 of them are married, if any of them are married. Like that family on that reality television show, I believe only one of them was actually married to the man. The others had just had these sort of spiritual commitment ceremonies. And so that's sort of how they were getting away with it, but they were still living a polygamous lifestyle, which was against the law. So the concept of bigamy is actually marrying more than one person. The concept of polygamy is living as a multi-person relationship. And, I get it why in the 1800s this mattered, because we needed people to be procreating and staying put in one place and creating these nuclear family units to build the population in the nation. But we're beyond that now. We're a mobile society. We have very different families and views now. We don't have those sort of agrarian, rural needs for the traditional nuclear family. I saw a hand in the back, I think.
It was me. It was the same question though.
Okay. And then tax issues are, I think, going to continue to be a little bit of an issue going forward, because just like the gap of time for marital property, there's also the gap of time where, for example, moving property back and forth as a spouse. So normally spouses can trade property back and forth without any tax consequences. But what about me, for example, being in a civil union in 2001, when I bought a car or something, and I later added my husband to the title. So should that have been taxable? It happened after the civil union, but should he have paid tax when I sold the car later? I don't know. But that's one of those sticky issues that will need to be addressed as we go forward. Real estate issues are also a big deal. And to understand that, you really have to think about how we title property in Florida. So you can own a property in fee simple by yourself. You can own a property as a joint tenant with someone else, or tenants in common. And that's where it's pretty much 50-50 if you're joint tenants. If it's tenancy in common, there's usually another person owning it with you, right? So probably 3 people. And then there's tenancy by the entirety, which when a married couple buys property together, it is presumed that they intend for it to be tenancy by the entirety. And that means that upon one of their deaths, that property is automatically going to transfer to the other spouse. You can also do the same thing with a joint tenancy with right of survivorship. So there are a number of different ways you can set up your property purchase. And a lot of couples who pre-marriage purchased a house together, for example, maybe they weren't well advised and they didn't bother to include the with right of survivorship language. And if you don't include that, then it is just a joint tenancy. And when your spouse dies, that property is going to move on over to, that half of your spouse's property will move on over to his family. So now you're a joint tenant with the family. So we don't know yet, like, again, this gap of time issue. If you bought the property after a civil union or domestic partnership registry and you failed to include with right of survivorship, shouldn't that be considered tenancy by the entirety, since you later followed up with a marriage to make that official? I don't know. There's also the issue of how homestead exemption would be applied in that scenario, because normally, if it's your homestead, then your spouse automatically inherits it upon your death. You don't even have to really file anything but a death certificate and affidavit of marriage. So again, it's going to be interesting for the next several years as we sort all this out. And I would be remiss if I didn't mention the status of marriage equality with Native American tribes. Right now, there are still 9 tribes that do not recognize marriage equality. There's probably 2 or 3 dozen tribes that may recognize marriage equality, but their law is not certain. And then there are maybe a dozen that do recognize. The Seminole tribe, I point out, because it's Florida, largely Florida, they do not recognize same-sex marriage. So if you plan to marry a Seminole, think twice.
No gators.
So, I think a lot of people don't realize that we have so many different Native American nations in this country, and each of them has their own legal system. So it's not as easy as just saying, oh, there's federal law and Florida law. There's also about 100 different tribes with their own set of laws. More current issues. I mentioned, how do we manage a couple that doesn't want to get married? And at Pride over the weekend, a couple approached me and actually said this. They were probably in their late 50s or 60s. It was a male couple. And they simply didn't believe in the idea that the government should have anything to do with what's going on in your household. So as a matter of principle and sort of libertarian viewpoint, they are not going to get married. But they do want to protect each other, right? They do want to see each other in the hospital if somebody gets sick. And there are ways that we can do that. In fact, before marriage equality, I did that all the time with documents for people. So things like a healthcare surrogate designation. You can say that person over there, my partner, even if you're not married, they're going to make my decisions, not my parents or my brothers or sisters. Your will is another way to do that. Transferring property outside of marriage, that it can be done, but it's tricky because you don't want to create a tax consequence for the spouse that's receiving sort of a gift of property. But yeah, we can still do this. You don't have to get married if you don't want to get married. Some people, I know a few lesbian couples that view, quote, marriage as a patriarchal concept that they're just not going to have any part of, even as we have equality. And that's fine by me, but at least protect each other with some basic documents. It does not cost a lot of money to do. Housing and employment discrimination is still a really big deal. So this has been a very confusing topic as well, because the Obama administration had put forth several executive orders to help prevent employment and housing discrimination. And the EEOC, which enforces all the civil rights statutes, they have recently changed their policy, and they're allowing claims of housing and sexual orientation. They're allowing those claims to go forward under the theory of gender discrimination. So the idea is that you're being discriminated against because you're a gay man, and the way you have arousal and sexual interest is not normal for the male sex. So that's the sort of underlying theory to get us there. The Circuit Court of Appeals, we have several in the United States. Like we're in the 11th Circuit, and the circuits are split on this issue. So this is only at the administrative EEOC level where this matters, and a couple of the circuits that have sided with the EEOC. So this is going to get to the Supreme Court eventually. I suspect it's going to be accepted for review probably in October, because we just had the 11th Circuit case. The ruling was in March, I think it was. And they have requested a rehearing en banc, and that means that only one judge heard the case and made the ruling in March, but now the plaintiffs are asking the entire set of federal judges at the 11th Circuit Court of Appeals to rehear the case. We don't know yet if they're going to accept it for rehearing. If they don't, then it will be a Supreme Court appeal, and that's what we need. We can't have this patchwork across the country of where you can and cannot be discriminated against. Within the state of Florida, it is also a patchwork. There are many counties and cities that have enacted ordinances to prevent housing and employment discrimination. The employment piece of it is almost always limited to government employment. It's very hard to force that on private employers. There are a few cities that have included private employers. So in Florida, you just don't know what you're going to get until you get there. And here in Escambia, Pensacola, we do not have any protections, so you can be fired for being gay or lesbian, or transgender, or bisexual, or any of the other alphabet that's involved these days. The exception, though, is that many private employers have adopted their own policies and procedures, and so if they discriminate against you in violation of their policy, then you may have a private breach of contract action because the employer breached their employment contract with you that was in their handbook. But generally speaking, it is extremely difficult in this jurisdiction to bring any sort of discrimination case based on sexual orientation or gender identity. And then, as I said, we have these new methods of solving family problems coming up, and I'm so excited we can talk about collaborative law now. So collaborative law is a cost-effective problem-solving approach that minimizes the impact of conflict on you and your children. So the idea is that rather than somebody filing a case and then the parties are back and forth exchanging documents and arguing over the stupidest stuff, from the beginning you agree to this process and the parties and their attorneys sign the collaborative process agreement. And this is now governed by statute and Florida bar rules as of July 1st it will be. And so each side has an attorney. Then the attorneys choose a neutral mental health expert to stay involved. And that neutral mental health person shows up to all of the negotiation meetings. They meet with the couple separately and together. And their role is not to be therapeutic, so it's not like going to therapy. Their role is to help everybody understand where the other party is coming from. Like, what is driving them for this particular position? And they go to all the meetings. And the case I'm working on now, that mental health counselor has been a godsend. I've never had a case, even despite some of the turmoil and negative going back and forth between the couple, it has been so much easier having a mental health person there to step in and say, what are y'all doing? And then any other experts that are involved in the case, for example, there's almost always a financial expert, unless the couple, is already in agreement about how they're going to split their property. And that person is neutral too. And so the couple pays for that person together, whereas in litigation, each couple is going to hire a CPA to be a forensic accountant to argue against each other in court. So each side is going to be paying this huge bill to this expert witnesses, and that almost doubles the cost of getting a divorce. There's no point in it because it's numbers, right? It's black and white math. This is not complicated stuff. So it makes much more sense to pay half the price and have one person be unbiased and neutral, and then black and white the best way to resolve the financial issue. And the same would be true if we needed a child care expert or a social worker. That expert would be neutral as we move forward. And if any of the parties at any time in the case, if they decide this isn't working for me, I want to litigate, then all of the people have to withdraw from the case, including the attorneys. So there's huge incentive to get it done in the collaborative process. And The benefits are obviously cost savings. It's much faster. You get through the court faster because you're filing it as an uncontested case, because nothing gets filed until you have a settlement. And it's healthier. You know, the cases that I've had that drag on for a couple of years, and I just like, what are you people arguing over? We have all the documents, we know your complete financial situation, there's nothing left to argue about. You're just arguing for the sake of arguing. And that is not what court is for. It is not for you to get revenge and vindication against your spouse that cheated on you. Handle that with your therapist. The court is there to help you resolve legal issues. And all too often, divorces rattle on through litigation just for the principle of the matter of getting the final word. And I don't do that anymore. I've stopped litigating, and collaborative law is the only method I'm offering. And I'm much happier for it. So West Florida Collaborative Law is our nonprofit organization in town. We're not an attorney referral service, but we are a consortium of all these different professionals. So it's not just attorneys. We have accountants in our group, and we have mental health persons in our group. And we work together to try to educate all of you about collaborative law, as well as our colleagues. So there are a lot of lawyers in this town that swore we would never have collaborative law here, and they are completely against it. Family attorneys, right? Because they think they're going to lose money if they're not litigating, right? You can't charge $30,000 in billing when you can solve the case in 5 meetings. So yeah, I'm going to lose some money, but I think that the volume increase is probably going to balance out.
Are there other states that are practicing collaborative law?
Yes, this is all over the world now. It started in 1990 in Wisconsin, and that attorney is actually still practicing. In Florida, it's been happening in South Florida for probably 10 years, and it sort of has moved its way up from Miami. And the statute was adopted late last year, I think it was, but it wasn't to become effective until the Florida Bar Association adopted rules to regulate the attorneys in this issue. They did that last month, and those rules go into effect July 1st, so the statute will be effective July 1st as well. And I'm going to ask that too, because this method is now being used in other practice areas. So in Florida, it's primarily family law, but a lot of business disputes and probate disputes, we're starting to see it there as well. And in fact, the case I'm working on now, they don't own a house, they don't have children because it's an older couple, but they did own a business together. And so primarily, this is a business case more than it is a divorce, because the operating agreement already explained what their percentages were. So I'm finding this is going to be really great for business disputes. Coincidentally, this is a divorce, but really it's a business case. So the future issues, I did a presentation on this question, could marriage equality be overturned, when I spoke to the Northwest Florida paralegals a while back. And the answer, surprisingly, is yes, it could be overturned. Extremely unlikely, but it is totally possible. So follow me through this. And this is Rick Santorum's idea. So in the late 90s, Nebraska adopted this partial birth abortion ban. And eventually that made its way to the Supreme Court, the US Supreme Court, and they said that it was unconstitutional because the language in the statute did not specifically define partial birth abortion very well. So as soon as the Republicans had control of the Congress, they adopted a nearly identical statute. It was a little more specific, but basically it was the exact same thing. And by that time, the Supreme Court was stacked with conservative judges. So they knew that they were adopting a statute that was already unconstitutional upon adoption, because they knew that if it were challenged, it would get to the Supreme Court, and the Supreme Court would uphold it, because now it was conservative judges, and it worked. So that is why we now have partial birth abortion bans. And I cannot tell you the definition of what a partial birth abortion is, but as I understand, it is not what the words imply. I don't know, I'm not an abortion expert, but this shows that Santorum suggested that they use this same political process to like as soon as his goal was to have Trump elected or whoever elected, and then when the court is stacked again with conservative justices, he wants Congress to make this move and try to undo marriage equality. I think even if that happened and it got to the Supreme Court, I really don't think that they would turn this around, because there have been so many gay and lesbian marriages since Overton fell that it would just be chaos. When California, they had marriage and then they didn't have marriage, and then finally it was really troubling and chaotic because nobody knew what their rights were, especially in divorce law. So it is possible, but I don't think it would ever happen. But then again, have you watched The Handmaid's Tale? So some other things that we need to do is we need to clean up some of the statutory language. The best example of that is the Surrogacy Statute. When you read the definitions of the Surrogacy Statute, it references the couple that wants the baby as the commissioning couple, but then it defines the commissioning couple as the intended father and mother. So that is not accurate for how it actually works for gay and lesbian couples. And the DMT case, that also, that was the lesbian, one of them had the egg, one carried it. That case also held that the surrogacy statute can be applied to gay and lesbian married people. So, but the statute still reads father and mother. It needs to be updated. The marriage ban and all of those statutes, they're still technically on the books, they're just not enforceable. So they need to be stricken from the books so that they're not part of our set of statutes any longer. And the surrogacy statute, by the way, it was adopted in 1993. The definitions have not been updated ever. There have been very, very few updates to that statute. And I think technically it's called the Reproductive Technology Act. And obviously, since 1993, we have had massive technological and medical improvements and changes. We need to revisit this statute and modernize it. The Employment Non-Discrimination Act, how many times are they going to introduce it in U.S. Congress and watch it not even get out of committee? It's way past time. Equal Rights Amendment. If we could get an Equal Rights Amendment, we wouldn't need the Employment Non-Discrimination Act. Mandatory health care recognition for transgender people. In Florida, hospitals cannot discriminate, hospitals and nursing homes cannot discriminate based on sexual orientation, but they still can discriminate against gender identity. So, health insurers do not have to treat transgender people equally. So we really need to address that. Name changes also. We've had this crazy name change case that this poor woman, transgender woman, she has been in this loop where she can't get her birth certificate because she doesn't have a government ID in her original birth name, because she's been living by that name since 1973. And she can't renew her driver's license because she can't get her birth certificate. And so we finally just got the order today, and I'm so glad we got it through. But that's an example of how the law needs to catch up so that these transgender individuals don't have to deal with these headaches that we take for granted about our identities. And then, of course, violence is an ongoing issue, especially for the transgender community. And I've included the latest run of letters because even I was surprised by the last few. So now we're up to LGBTQIA PQ. And the rest of it, we all know what LGBT is queer. I still don't feel like I have a grasp on what people mean when they say that they identify as queer. I don't disrespect it. I'm not able to wrap my head around what's different about it. Intersex is a physical thing, right? Asexual, not interested in sex. Pansexual, interested in a variety of sexual identities. But polyamorous and kink, I'm not sure that they fit into this acronym, right? Because all these other things are very innate characteristics. But how many people to have a relationship with and what fetishes you might have in a sexual relationship, those really are choices, right? It's not really something that you're born with and can't change. I know some people will disagree with me on that, I'm kind of left scratching my head as to why we include those two in the acronym now. Is anybody using this full acronym?
I feel quite progressive in adding the Q, because for the life of me, I was LGBT, and then I felt very progressive in adding the Q. I didn't know that the IAPPK existed. And again, not in no disrespect, but I would have no clue, and I feel quite progressive in my LGBTQ identity, but yeah, that I would.
At Capitol Pride a few weeks ago in Washington, D.C., there was a lot of discussion about how far are we going to go with subdividing the community. Because the more labels we create, the more we separate ourselves from each other and stop talking to each other. And we need the whole community to be together and one unit to keep moving things forward. We can't ignore those innate characteristics, right? But if we separate the transgender people over there and I only pay attention to my gay friends, that's really a terrible thing, because the transgender community needs the gay men and the lesbians and the bisexuals to help them on to the next part of their civil rights.
The blanket queer, a lot of young people today have taken it back as like the offensive term it used to be. It's more of a blanket term. Queer itself is so you don't have to necessarily say, well, I'm bisexual, I'm pansexual, I'm gay. It's just like, I am not straight. And genderqueer is anyone who is transgender, gender nonconforming, anything that isn't cisgender would be genderqueer. So it's just a blanket term, instead of having to specifically say, well, I'm gay or I'm bisexual.
That's a really good explanation. Thank you so much. So that's where I am on all that. And I say too that the first time I started hearing these terms, it was at UWF. So I'm glad we're at a college campus so that a young person can tune in all those old people. So really, I do want you to know that I'm here to help the LGBT community. I love representing my clients, and I really, I don't want to say I've become affectionate to them, but I do have like an affinity towards my clients. I appreciate them so much, and I really want to help them in the future. I don't want people to just come to me one time. So my team, my clients are always great about my staff and how much they like them. Me, obviously, and you can email me at this address, which it actually goes to Dustin. I'm not as nice as Elizabeth that way. So Dustin is my paralegal, who will be sitting at the table taking your money to sell the books. And that's his email address. And then Andy Davis, who many of you know, is my office manager. And I think he's going to be leaving us soon, so if you don't get a response from him, don't worry about it. But he is heading up the Coastal Cabaret Ensemble that's performing at the gala. And here is our contact information. So I really appreciate the time. I don't know what time it is or how long I went, but oh wow, I went a long time. So if you have any questions at all, please call me or email us anytime. Even if you know that you cannot afford to hire an attorney for legal services, at least come have a consult, right? If you weren't sure why your knee hurts, you would go consult with a doctor. You might have to go further and get surgery. So just come see me and let's talk about whatever's going on. And maybe you do need me, maybe you don't. And maybe you can afford it, maybe you can't. But if you can't afford the legal service, I will help you find a way to get it done, right? I'm not going to turn people out in the cold and say, oh, they can't pay. I will still communicate with you and we'll figure it out. All right, thanks so much, I appreciate it.
Before we break up here tonight, there's two things, probably the two most important things, and I forgot to mention them. Firstly, I really want to thank Joshua for coming on such short notice. It was literally about this time last night when I had the idea that if our speakers couldn't come, because this time last night we didn't know for sure they weren't coming, but if they can't come, if Josh was available, I knew he would do a good job. And he did a great job, didn't he? Thank you, Joshua. Joshua has always been a friend to me personally and to the LGBT community. I used to, in another life, I was a newspaper reporter, and Josh was always good to help me with stories when I needed it. He's helped me with some legal questions in my personal life. And I believe that I wasn't involved, Joshua, but didn't you help the nonprofit incorporation papers for Gay Grassroots?
I was sort of a sounding board, but I didn't do it myself.
Okay, I knew you were involved somehow. So he really is the real deal. He loves the LGBT people in this community and wants to help. So that's great. The other thing is the reason we are here at this beautiful facility tonight is because the Gay Straight Alliance, or the GSA, at Pensacola State College. It's a very interesting story. I had these two speakers who were going to come to town, and I really wanted a nice place, and we've used different facilities for different programs. We had a program, like I said, at the library on Monday night, which is a great facility. We're having one at the Opera Center on Saturday night, different places. But I really wanted something nice. Would like an academic environment. And I have a friend who works in the counseling office at PSC, James Blackwell, and I contacted him and I said, James, how can we get on campus at PSC? Who would I talk to? And he reached out to Dr. Meyer, and I don't think they knew each other. You didn't know each other, did you? He tracked her down, I think, through somebody else. Anyway, and they're like, well, you need to, you're gay people out of the college. There's gay people in the college. We need to get y'all gay people together. And from that came this. And personally, probably the best thing about tonight's event is that I, and by extension Gay Grassroots, now has a relationship with the GSA and with Dr. Meyer. And I am so grateful for that. This community is not as cohesive as it should be. The LGBT community, and I include a bunch of straight people and kinky people and all kinds of people when I talk about the LGBT community, because it's us and our allies. We can't get anything done alone, but together we can get anything done. Did I screw that up? Anyway, but thank you all for coming out. There are books on sale in the back, t-shirts, memberships. Don't forget your ball tickets. And happy Gay Pride. Thanks.